Hi, I'm Jason Knutson. I'm one of the lawyers at the Madison office of Havish, and Rotier.
And I'm Guy Dubois. I'm an attorney with Axley Brentelson here in Madison.
We're here talking about an article that you'll see in the Wisconsin Lawyer magazine talking about the relationship of physicians and lawyers and how to make that relationship stronger and work even better. Dealing with treating doctors can be a challenge, in part because they are just so busy. These are people who are seeing patients all day or in surgery all day, and really one of the last things they want to do is deal with an attorney on a personal injury case. There are a number of reasons for that. I think primarily it has to do with them just being afraid of what's going to happen. We assume that doctors are familiar with the legal system because our professions interact so often. But I think that for the most part, doctors keep themselves ignorant to some degree of the legal system because they just don't want to deal with it at all. And when they do, unfortunately, they can have some bad interactions that can color the rest of the interactions they have with lawyers.
Sure, that's right. And a lot of times, their brushes with the legal system may involve, could be a messy divorce, it could be a breakup of a partnership that they have, they may deal with their tax attorneys, they may find themselves the subject of a medical malpractice action. None of those are particularly pleasant interactions. So when they are called upon to try to help in a particular case, it's not always necessarily something that they're going to embrace doing right out of the get-go.
Right, and for that reason, I think the most important part in building relationships with doctors is to take the time to address what their concerns likely are. Generally, they aren't going to tell you what they are, at least that's my experience. And so you have to anticipate what they are. Oftentimes, it's just not knowing how they fit in. So from a plaintiff's personal injury attorney, typically a treating physician is going to be an expert witness for you. They don't know what that means, and they don't know what their responsibilities are, and really they don't know where to start in terms of what to review or how to get ready. And so the easiest way to get them pointed in the right direction is really to just make a phone call and to tell them, here's where we are in this process, here's your role, here's what we need to talk about, and then help them to get ready for what they need to do. Right. When is it okay to just call a nurse's desk or call the physician directly and start talking to them about issues?
Well, I guess it depends who you are. If you're representing the patient, you have some latitude and leeway to do that the defense counsel simply does not. Obviously, under federal HIPAA laws, under Wisconsin sections 14682, doctors know that they have to keep medical information, protected health information, private, and they're going to erect those barriers. They won't just speak freely with you. You may need to get an authorization to talk to them. Obviously, from a plaintiff's perspective, usually the patient will give you that authorization. From a defense perspective, you don't have that. Oftentimes, when I'm defending a case, and it's not a medical malpractice case where I've had a chance to visit with the physician, my one shot is that deposition, and that's how I get to talk to these folks. Another thing that I think it bears mentioning and keeping in mind, especially for attorneys, is that certainly in the prosecution of PI-type cases, we need them. They really do not need us. So we're coming to them asking for their time, asking for their expertise, and something that they could just as soon do without. Several things that I think are particularly important in being able to deal with physicians, and the first thing is you have to have some sort of basic understanding of the medicine that's involved. These people do not want to come in and start at square one with you. You have to be able to know what issues they've dealt with. You have to have an idea of how that fits into the overall practice of medicine. And then you have to be able to be prepared to have an intelligent conversation with them. If you start at that point, then it's much easier for them to interact. They can easily become teachers, they can become colleagues, they can become somebody that will actually work with you. But if they feel that they're having to start at square one, that's just an added burden for them.
That's a great point. And I think on the opposite end of the spectrum, don't overcorrect and think that you know more medicine than the physicians do, because you just don't. And that's one of the quickest ways to turn them off from helping you is to come in and basically tell them you figured the medicine out and here's what you think is going on. They know they don't know as much about the law as we do. We need to remember we don't know nearly as much about the medicine as they do, even though maybe we've had more time to sit on this particular case and study it.
That's right. And I think that's a point that's especially sentient for folks on the defense side of of a case. If you think about it, when a PI case comes into Jason's office, one of the first things he's going to do is going to review medical records. In order to do that appropriately, he has to understand what's there, and he's found something in those medical records that he believes supports the claim. Now, when that case makes its way to a defense counsel's office, their job, in part, is to question that. So when defense counsel's first interaction with the doctor is to come in to actually question their medical conclusions, again, that's not starting at a place that is necessarily easy or comfortable for a physician.
Getting back to learning the medicine, how do you start to dive in? I know you've had enough experience now where there really isn't an issue you haven't seen, but when there's something medically new to you, how do you get into it?
There are a number of things that are out there as resources. Obviously, the internet is a great resource. As long as you know the actual medical terminology for something, you can Google it. And you would be surprised at the amount of information that comes up that way. There are a few services out there that will give you access to professional, peer-reviewed medical journal articles, some of them for a small fee, but not an outlandish fee, where you can actually read these articles, kind of get up to speed into what the thinking is. There's another service that some people subscribe to. It's called Up to Date. This is one of the things that physicians use very regularly when they, too, are dealing with something that they haven't seen previously. It's a service that will give them a short primer on any particular medical topic that's out there. And if you can combine Wikipedia and Up to Date, you're going to have at least a good working understanding of what the medical issues are.
We talked a little bit about preparing the doctors to get ready for whatever the task at hand is, whether it's as a treating physician or a defendant or whatever else in a case, and giving them the materials. What my office does is prepare generally a binder for these doctors to look at, and it includes things like the pertinent medical records. If someone else has issued a report, for instance an IME, and I think it would be useful for them to see that, that will be in there as well. What it does not include is a bunch of material that isn't going to be relevant to the medicine at all. That can be things like the face sheets, a lot of insurance information, things that we can really call out. And then you also have to be careful just not to give them too much information. Remember, these physicians not only have too much to do, but they're more and more used to paperless charts. And so the idea of having to flip through 100 pages of medical records or some other documents again is a real big deterrent to getting them to get to work on your file.
That's right. And that's obviously from the plaintiff's perspective, you want to provide the physician with whatever it is that they're going to need to review in order to support what you're thinking, but the same applies to defense counsel as well. If you're challenging an opinion in a case, you obviously have a reason for doing that. You too have seen something in the medical records that you think counteracts or contradicts the conclusion that that's going to be supported. You want to be prepared to provide that to the physician at their deposition as well too. You have to be a little careful. It's not necessarily going to be a gotcha moment because these people aren't out to play gotcha. They're more interested in an intelligent, informed conversation of what the issues are. So if you think that you are aware of other records that maybe undercut a plaintiff's claim, what you want to do is you want to be able to present those. Say, now, were you aware of these things? How do you interpret them? How do they fit into your opinions?
Right, and the doctors really appreciate having that information. They don't like being caught flat-footed at a deposition and seeing some record or note for the first time that they haven't seen. And so that's one way to really motivate them to actually go through some records that aren't their own, is to remind them this is a way for you to know what's out there so you can see what questions are coming. And speaking of motivating the physicians, there are really two things I've seen in my career that separate good lawyers from really good lawyers. The really good lawyers, number one, actually read the cases, and the really good lawyers also spend time motivating and preparing the physicians that they work with. It isn't just a matter of showing up for a deposition and not having done anything to get a doctor ready. The really good lawyers have thought about how this doctor fits in and what they can do to motivate that doctor to make them either an advocate in their case or at least present the way that they need to make the case stronger. And that requires some time. It just requires some time to think about the case and then to think about how to prepare this particular doctor. For instance, if you're dealing with a trauma surgeon, you're not going to have a lot of time. You're probably dealing with someone who's used to a fast-paced environment, and so you really need to give them bullet points to get into it. On the other hand, maybe if you're dealing with a family practice physician, that's someone who does take more time to really get to know their patient and what makes them tick, and that's someone where maybe you can talk about the day-to-day effects that an accident or an injury is having on someone's life, and that will resonate more with that physician. But taking the time to frame the case for the physician makes an incredible difference, I think, in how they end up presenting.
Mm-hmm. And I think a corollary to that, and this also goes back to understanding the medicine underlying it, oftentimes if you're dealing with a serious injury, somebody who's been hospitalized, somebody who's had complications throughout their hospitalization, you're going to be dealing with a number of different specialists. It's not always going to be practical from the plaintiff's perspective or from any sort of perspective to drag all these people in for testimony. And sometimes it's necessary, but you also have to have an appreciation. Are you pushing this particular physician outside their comfort zone? The example that I always give is that every personal injury litigator had to take a trust in the state's class. That doesn't necessarily mean that you would feel comfortable, advising on trust in the state's issue. Same thing with docs. Cardiologist may be one of the best cardiologists out there. It doesn't necessarily mean that she has expertise in some other specialty. So you want to bear in mind what the person that you're going to be dealing with really knows and what they're comfortable with, so that you can tease out of them things that remain within their comfort zone.
Yeah, that is a great point. Speaking of comfort zone, one of the areas where it seems attorneys are least comfortable is trying to figure out when the alt privilege applies and what it means. It isn't always implicated in your run-of-the-mill personal injury case. I know you deal with it much more often in medical malpractice cases, but maybe you can just quickly describe how you see alt and then where you see it come up in those types of cases.
Sure. Alt, the case that Jason is referring to is came down, I guess probably almost 10 years ago now at this point, and it stands for the proposition that you cannot compel someone to give expert testimony against their will, absent certain compelling circumstances. There have been a couple cases that have come down the pike since then that really, I think, stand for the proposition that there are no such thing as compelling circumstances, but rather some very narrow exceptions in dealing with a physician's own care. Oftentimes, especially in larger organizations, when physicians know they're going to be deposed, they will have a brief 5-10 minute meeting with their in-house counsel. They'll be advised as to what their alt privileges are. Again, I've seen attorneys struggle with really understanding the parameters of the three cases under that doctrine right now. That doesn't necessarily mean a physician without any legal training is going to have a full appreciation. And what happens is they will err on the side of caution. They will think that they should not be giving testimony, which, perhaps under another circumstance they really would be compelled to give. So it's drawing that line between what is expert testimony and what is fact testimony, and that's not always easy to do, especially when you're dealing with a physician who has made expert judgments in the course of providing treatment for a particular patient.
And if you are a plaintiff's lawyer and a physician is being told to invoke that alt privilege, what do you do? What's your remedy as you're sitting in a deposition and a physician's being told not to answer?
Well, really, at that point, because it is a privilege, I would assume that certainly if I was the one advising the physician not to answer the question, the physician better know not to answer the question. And I think your remedy at that point is to go ahead and make your record, so that when you go to the judge and ask for an order compelling that physician to come back and answer the question that you propose, the judge can understand the context, the judge can understand why you think it falls within an exception to alt or whether it's not even covered by alt.
Right, and then just a quick trial practice pointer, and one that I learned from Guy, is that alt privilege need not be invoked in front of the jury.
Right.
So if you find yourself in front of the jury, you're that far down the road, make sure it's something that you deal with in advance, either as a motion in limine or before the jury comes in, so that the jury doesn't see your physician take that privilege. One of the things we should touch on, and it will sound a bit glib, is you got to be nice to doctors' staff. As attorneys, I think we're so used to relying on our staff, and the environment that they work in is maybe a little more callous than some of the healthcare environments that they're in. Physician staff really are gatekeepers for them, and you may never get to a physician if you aren't nice to their staff. You really have to do it. And one of the worst things you can do is just send documents, legal documents, subpoenas, anything else like that, without a heads up to the physician and the staff. They need to know what's coming and what it means. And if you build relationships with physician staff, nurses, secretaries, assistants, it's going to make things so much easier as you start to schedule times to prepare them or even just to get their deposition set.
I think that's right. And again, another point that goes hand in hand with that, and it goes to the idea of civility. We were all told that we need to be more civil with one another, and I think that in the context of dealing among attorneys who are used to arguing, who are, by nature, in an adversarial situation, we interpret civility to mean one thing. Physicians, nurses, they're healers. They really do take that role very seriously. They understand that they're there to help. What they define as civil is probably not what most litigators define as civil.
Mm-hmm.
As a matter of fact, they wonder why we squabble the way we do. So, bear in mind that you're actually dealing with folks who are going out of their way to be nice, caring individuals and may not necessarily be comfortable with an adversarial situation. Yeah, if you'd like to learn a little bit more, obviously we have the article coming out in the February issue of Wisconsin Lawyer, and then I believe Jason and I will be presenting a CLE at the State Bar coming up this spring, I think in May.
Thank you.
Thanks.